Thank you, Chairman. Commissioner, Chairwoman, welcome. I have a number of different questions. I'm going to bounce around. I'm going to spend just a short time on the prison closings because I know that several of my colleagues are going to be addressing that. When I look at some data provided through the Department of Corrections website, and it indicates at medium correctional facilities over the past number of years, past 10 years, dating to 2003, the percentage of violent felony offenders in the medium population has increased from 48% to 56%. And the specific question I have with the closing of a minimum secure facility is the concern about moving inmates classified minimum secure and housing them in medium secure facilities that are becoming more violent. And what consideration have you given regarding that?
The classification is primarily based on time to service, actually time to release. And we do have we haven't seen, obviously, an increase in the number of violent offenders. However, sometimes a violent offender, you have to be very careful as to what we call a violent offender. Many of them are in for what we call VFO crimes, but are not necessarily violent people in the classic sense. We look at both the nature of the crime, the time they have to go before their release, and clearly also the behavior of them while they're in the prison system. An individual could come in with only 2 years, but should he or she assault an officer or another inmate, we would then reclassify that person to a medium security. So it's a constantly fluid situation. I think we have a tendency to have more data than we can always explain, and sometimes the data is not really reflective of the individuals that we're talking about. My experience so far has taught me something more than I thought I would. The numbers don't tell us about the person, and that's complicating it. So to answer your basic question is, we place people that we believe are suitable for medium security settings, regardless of their crime. You could have a person who spent 20 years in a maximum security prison. He'll be going home in 5 years. He's done a very good time in terms of his behavior. He deserves to be placed in a medium security facility. That doesn't change our ability to supervise him.
Well, understood. For the sake of time and statistics aside, the concern is the safety of the staff and the inmates. But clearly more to follow in the discussion over the next month or so. The other, an additional question I have about that actually has to do with the law and the requirement for notification of staff of the closing of 1 year. And again, like last year, now the Article 7 language is proposing to notwithstand that and provide 60-day notice, which causes tremendous upheaval in communities and families. I mean, why the disregard of a law that has been in place for a period of time and probably preceded me, but well thought out, and in place for good reason?
You're referring to 79.A and B, which we
yes.
have in place. Although last year, 2 years ago actually, notwithstanding again, we closed 7 prisons within basically 6 months. It's not ideal, but it is workable. I think the very reason the governor has been forced basically to do the notwithstanding is the economic impact. The savings is necessary. I would argue that these 2 particular facilities, the numbers of people involved, both staff and inmates, are significantly lower than it certainly were when we closed 7 prisons. And I believe 60 days is really the notification. There'll be another 60 days before staff and offenders will actually be moved. So we do have some flexibility. But the primary reason is to gather as much savings as we can this fiscal year coming up.
For the sake of time, I appreciate your answer, but of course, I'd welcome more discussion as we go through the whole process. In speaking of the cost of staff and administration, we look at the facilities across the state, and I know it's been proposed in the past, where we have facilities that are located in close proximity to each other or across the street, like in Attica, Wyoming, for instance. If you've given consideration to the combining of that upper-level administration at the facilities, one person, for instance, in charge of the properties, one person in charge of programs, and so on, as opposed to a superintendent at each location, deputy superintendents at each location. And if we need to change the law to accommodate that, we certainly could do that.
We have looked at, and I must take a position that I don't agree with that kind of combination. I will also tell you that over the last several years, we have complicated our facilities significantly. Many of the facilities that you have next to each other provide a lot of services that we didn't do before. I don't want to keep pushing it on certain kinds of offenders, but we have 15% of our offenders mentally ill, and 13% of our offenders are sex offenders. We have some complicated programs and complicated administrations. I've also placed, as one of the reasons we're looking at while I will stay with single administrations, we put more and more pressure on the executive people at each facility to take a look at how we handle our special housing, how we're handling our PREA events. PREA is a major, major initiative that I don't think most people understand how complicated it is in terms of our requirement to respond. I do not believe a single administration can handle two large facilities and provide the kind of services, both to staff and inmates, that are required.
Well, I will say, I do appreciate how complicated it was. I've spent a career in criminal justice, and I'm very familiar with it. So I do welcome further discussions as we move forward. I'll also separately ask, I'd like to have a discussion about the population trends, about the housing, general confinement versus special housing and those things, but I'll save it for committee if you have a willingness to come to the committee so we can talk about that. If we can move over to community supervision or parole now, and I guess the question could be for either one of you. Last year we saw the elimination of the title facility parole officer and the phasing into, or I think it was the creation of a new title, the offender rehab counselor. And my question has to do is, I'm curious how that's going, what economic impact it may have had, but really my larger question is, how is it going operationally? Is it successful? Are there problems with it?
I think it's very successful, and I think you need to go back as to why we did it. Historically, you had basically two sets of staff who would deal with the offender inside the prison. One is the correction counselor, and one was the facility parole officer. And it was very clear that communication could be improved if there was the same single group. Part of the merger rationalization was both to streamline the entire process. And our goal, and it's working rather well, and it's a work in progress, I will grant you, but our primary goal is that when an offender comes into a prison and he has an offender rehabilitation counselor, which was a civil service title, which we weren't overly pleased with, but there is no more diversion or division of services. One of the things that someone will probably ask, I imagine, and is our concept of using what we call a compass. The compass is a research-based program. It's an assessment tool, if you would. Well, we've taken the steps to do this. We now do a compass on the intake when they arrive at the facility. That compass now provides us with a treatment plan. Prior to their leaving, before they go to parole board, we do another compass, which kind of reassesses what they've done and their risk level for community supervision.
I'm sorry to cut you off, but I'm mindful of the clock in front of you that's winding down on me. And I have 10 seconds to ask one last question.
Absolutely.
So I do appreciate the answer. I continue to hear anecdotal stories from inmates, from staff, and others about the concern of drugs being inside the facilities. And my question is, not so much, I guess, short answer, I guess, how are you dealing with that, and are funds allocated to trying to ensure that drugs are kept out of facilities? Illegal drugs, of course.
Drugs is a major problem to us, and contrary to what some people would argue, it's not a big problem. You catch somebody using drugs, or catch somebody with little drugs. It's what's behind the drugs that's my concern in terms of safety and security. If someone is carrying drugs, he got it somehow, he had to pay for it. Drugs nationally is a major problem within all prison systems, and we do, in fact, spend a lot of time into injection. Most of our recent drug arrests have come, unfortunately, with visitors coming in with drugs. I have a very expensive and very extensive investigation unit called my IG, Inspector General's office. That office alone spends inordinate amount of time trying to ascertain who's bringing drugs in and going after them. So, short answer is, drugs is a major, major problem for us, and it does impact on who, in fact, winds up in special housing because of what's behind the drug addiction.
Thank you.
Thank you.
Chairman.
Assembly.
Senator Gallivan.
Thank you, Chairman. Chairwoman, I didn't realize it was your last day. I sit in a unique position in having served with you on the parole board, with you as my chairwoman.
That's right.
And I just want to say that I did value our relationship, and I thank you for our time together, and your efforts, your leadership, and wish you well.
Thank you so much.
My pleasure. Commissioner, one last question. It has to do with the various temporary release programs. And you are required by law to provide a report to the legislature on the yearly statistics. And as timing would have it, I received it yesterday and took a look at it. I look at the number of applications, which are significant, 11,000 or so. The number that were approved at the facilities is 599, about 5% of that. And of those 599 forward to central office, 33 were approved at central office. And I'm not questioning the criteria or saying it should be higher or lower who was ultimately approved. But it looks to me that there's some sort of administrative disconnect there, that it could produce, it seems like there's an inordinate amount of paperwork being done. Either the inmates aren't fully aware of the guidelines surrounding it when they submit it, and then at the facility level, I don't know if at the facility level they're fully aware of the guidelines that central office sets and makes the determination. So I'm looking at that and suggesting that might be a way to streamline some administrative operations without knowing any of the details, unless I'm completely missing something.
No, I'm smiling because I saw those. It was on my desk for several days. I had the same problem you did in terms of the numbers, and we do, in fact, have some people looking over it. Part of the problem is eligibility is the broad definition, and when you get down to it, they may be eligible on the current crime, but in fact, they have previous crimes which then make them ineligible. The other issue is the facilities taking a look at these individuals who know them pretty well and frankly are not comfortable recommending them for work release at that time. But I think you will see some changes. We're sending some people out there to do exactly what you just alluded to. Let's take a closer look at those disparities of numbers. I will tell you, though, we can open up as much as we can, but the day of the work release as it was in the 80s and 90s is just not there, primarily because of the restriction on VFOs.
Okay, thank you. Thanks, Chairman. Thanks, Chairman. Thanks for being here, Superintendent. Let me start with what you just finished with, the integrity, knowledge, dedication, and quality of our men and women that distinguishes the state police. I couldn't have said it better.
Thank you.
And I would also be remiss if I didn't thank you for your professionalism and leadership. I maintain contact with law enforcement executives throughout the country, and clearly the state police is one of the premier agencies in the country because of you, those that went before you, and of course all the men and women. And I stand ready to help you in your mission. I want to talk about, I know that the additional 2 classes coming are welcome, and it'll increase the strength from what it is today. My question has to do, because I do hear this from time to time, mostly out in Western New York, which A and E Troop areas, but then I pick it up from other parts of the state. And the question has to do with the deployment, how you're spreading your patrol troopers out throughout the state and determining where they go, where they're assigned, the location of stations, concern about some stations being in communities that have local law enforcement that act as the first responders in that particular town or village. But the larger picture, can you just talk about your deployment, how you deploy, and your plans going forward with the increase in strength.
Sure. In the last academy class, which graduated 133 recruits, we tried to apply a formula that took into account workload. And we measured a number of items, including Part 1 crimes, vehicle accidents, traffic enforcement, number of responses. It's a nationally recognized formula, and it fits us the best. A lot of the other formulas that agencies use for deployment rely on population, which really didn't work for us as an agency that covers many rural areas within the state. You know, we deployed using that. We had a limited number of people. Some of the troops not having been backfilled for at least 3 years since we had our last academy class had bigger voids than others. You know, we're looking forward to the 197 recruits we currently have in to correct some of the deployment issues. But, you know, basically it was based on activity and need. You know, as you go around the state and Senator, you would know this very well. Our role differs in every community where we serve. There's communities where we are the primary police agency. There's others where we share responsibility. Others where we support only in investigative and special needs. You know, I think that when you say there's communities maybe that don't have as big a need for state police, you know, we all work cooperatively together to offer the best public safety that we can. You know, there's times where sheriff's offices put out a lot of staffing, and other times where they don't, where they need supplement of the state police. So to say that there's communities where we're not needed because of locals, you know, you have to take them on an individual basis.
I'm tempted to talk about the SAFE Act and its implications for the state police, but because of the size of that topic, I'll defer that. But just want you to know that that remains a concern for me, and we'll have discussions going forward. One area the only other area I wanted to talk about is the governor's proposal with the restricted plea bargaining. And I know that over the past number of years, and as this has evolved, there was concerns with the amount of time, both in terms of the troopers' time and then, of course, the dollars spent in overtime, with troopers having to go to local courts for traffic tickets that were ultimately plead down. And the system has evolved over the years. Now, it seems to me what is a little bit lost in all this, and I don't know if you've taken it into account in your budget, that there'll be quite a significant impact if the governor's proposal goes through on troopers now being, greater number of troopers being required to be in court to testify in all these local criminal courts, which I would imagine would impact patrol, would impact your overtime budget. Has that been taken into account?
Well, we've looked at the plea bargaining bill that's on the table, and, you know, as far as it affects the state police, the way we deploy our personnel or the way we assign patrols will not be affected, obviously, because we would deploy based on traffic and accident and fatality statistics. When it comes to the plea bargaining side, obviously the fines in the plea bargaining fall into the local courts. I mean, the number that I've seen used is 20,000 cases of speed over 20 miles an hour that are currently pled that may not be pled down to parking violations. So I think that's the universe that we've been looking at. I think a good number of those will still plea. I think some of them will choose to go to trial. Over the last couple of years, we've done a fairly decent job of reducing court-related overtime. A lot of that was helped by the legislation last year, which no longer requires our troopers to appear on the first appearance in traffic court. You know, it's hard to estimate the actual impact it's going to have on us, but as I said, we're doing well this year with reduction of court-related overtime, and I think there is some cushion in there.
All right, thank you. I look forward in my new capacity with this Crime and Corrections Committee, working with you as we move forward. Thank you, Chairman.
Thank you.